Hey everyone, Harry here to talk about Representative Scott Perry and an order that was finally given yesterday that about 1,700 records, those could be texts, they could be whatever would be on his phone, be turned over or be permitted to be used as evidence in the investigation by Jack Smith. Okay, that's normally a very first step, right? You seize a phone and you have to have a search warrant to do it. And then you figure out what's going on. And in fact, that is what happened here 18 months ago. What's been going on since then? Perry has interposed objections under the speech or debate clause. He's saying all these communications are privileged. I'm a legislator and I have protection under the speech or debate clause. He is a legislator. He does have protection under the speech or debate clause, but that doesn't mean that anything that comes out of his mouth or his fingertips is protected. So what's been going on over these last almost 18 months has been an effort to distinguish messages covered by the speech or debate clause and therefore not subject to use by the United States versus ones that aren't. And I say not subject to use because the very first thing, they get a search warrant and they make a copy of all the data on it. They have the information already. So anyone who's been concerned, wait, has he been able to delete it or anything like that? No. But you need another search warrant for which they applied to be able to use it as evidence in the investigation. And that's the tussle that Perry has been interposing his speech or debate objections. And it's taken a pretty tortuous path up and down the ranks of the D.C. federal court. So the Chief Judge Beryl Howe, made a cut and found that about 90% of records, communications, we use the term records to encompass everything that it could be, are not covered by speech or debate. Perry appealed that ruling, and a pretty conservative panel, including Trump's appointee to the D.C. Circuit, said that Howell had been mistaken because she had applied too restrictive a test under the speech or debate clause. And in particular, non-legislative activity, that is, the clear paradigm, you're on the floor, you're voting, you're discussing how to vote, etc. And so, but what other than that counts as speech or debate protection? The Court of Appeals said if it's integral to that kind of legislative activity, then it also counts. And they said Howell had been a little bit too permissive. So they bounced it back to the Chief Judge, who is now a different person, Judge Boasberg. And he's done a painstaking review of these something like 2,200 records, according to the standard, the legal standard that the D.C. Circuit promulgated. And so it includes protection for records that are integral to legislative activity. So having done that, he comes up with a list of about 75% of all the records, quite a lot. And he subdivides the whole kit and caboodle into 9 categories and basically says 2 of those categories might be integral, so won't turn them over. But the 7 have plenty of good stuff, including communications with third persons and communications that, really don't have anything to do with legislation. And remember Perry's apparent role here. He is neck deep in all the post-election stuff. And in particular, we don't know exactly how this connection was made, but he's the genius who identifies Jeff Clark, the man who would be king in the DOJ, as someone who could be useful to Trump because Flunky Clark, was available to write Georgia and say that the DOJ had found fault with Georgia's election. And in Trump's words, once that happens, let my Republican allies in Congress take it from there. Only one problem. The DOJ had not found any problem in Florida. And when Clark tried to throw his borrowed weight, borrowed from the president, around, he created a total crisis in DOJ. And Trump was ready to make Clark the acting attorney general. Clark was arrogantly, telling the guys who were above him, who are above him still, it looks like maybe for 30 seconds, he occupied the perch of assistant attorney general, but on a phone log. But anyway, he was telling them, just play ball with me and I'll let you keep your job kind of stuff. And it was a total meltdown, a total shit show would be the legal term, and where there's the everyone goes over to the White House. There's a showdown. Pat Cipollone and all grown-ups take the side of the top dogs at DOJ and tell Trump if he tries to do this and strong arm Clark into the role, they're all resigning, and it's going to be, a Saturday night massacre on steroids, at which point Trump backs down. But it's still part of the overall conspiracy with plenty of overt acts and the like. And so far, basically everybody in the Capitol, all members of Congress, have had a pass. And we know that that plenty of them were at least kibitzers here. And in particular, Mark Meadows seems to have been the conduit for all the interested members of Congress who were more than happy to bend or break the law. But they really are focused on Perry because he's got such an operational role. He's the guy who literally makes the marriage between Trump and Jeff Clark. And that if that letter, if Trump had said, I don't care, you guys all resign, the letter had been sent out, false though it was, who knows what might have transpired. In any event, Scott Perry's records, which we already know are the ones not protected by speech or debate, so can be used in an investigation against him, figure to be very fertile information about his own role that seems to me, if Jeff Clark is a co-conspirator here or was able to be charged, that Scott Perry now might be in the soup as well, which would be really significant because it would spread the whole post-election scandal, which, has been basically Team Trump and allies in the executive branch and in his own sort of kitchen cabinet over to Congress. And it would make the as a matter of history and maybe as a matter of law and maybe as a matter of who goes to jail, a kind of interbranch affair that would just, there's not room for any more black eyes here in government, but would really be a scandal. And when history records as full an account as it can, it would include the role of legislators such as Scott Perry, not to mention the possibility of a felony indictment or other things that could personally end his career. So even though this is just one procedural step, the last one in 18 months of trying to get at these records, it's a big one because it introduces the whole concrete possibility of a legislator, a member of the House, being brought into the whole fray of the post election set of conspiracies. So it really bears watching carefully what happens next and how the potential charges against Scott Perry play out. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.